I am not the dead entity, Anthony Griffin. I am the executor of the estate. I do not agree to be.
All right, well, we'll have to set this over and hold you in custody then.
Because you're obstructing my justice.
Your objection is noted.
I'm a more. You have.
If you keep talking over me, we're going to cancel this.
Talking over me. I just want to state the facts. Do you not want the facts to be stated on the case? Am I not allowed?
I mean, you're not allowed. No, you're not allowed to talk about
an attorney. I am not.
Okay,
then I am going to be imposing other penalties, meaning for you jail time.
Again,
Mr. Mattson, all right.
Recorder.
I'm going to mute Mr. Mattson again because he continues to interrupt me with a line of argument that I don't even know what to say about it. It just is, it's not a legal argument at all.
I'm sorry, who do we have here? This is Mr. Griffin.
Anthony. I'm not. I asked for assistant counsel, not counsel.
That's fine.
We'll go on the record in the state of Wisconsin versus Anthony Griffin Jr., case number 25 CF 939. Could you get the appearances, please?
Assistant District Attorney Jack Schneider for the state of Wisconsin.
And you're Mr. Griffin, is that correct?
No, all statements for the record comes now the living man, Anthony of the Griffin family.
All right, so Mr. Griffin,
appearing expressly.
wait, you need to stop talking. Is
I'm
Mr. Griffin
appearing expressly.
hearing today? Are you Mr. Griffin or not?
I am Anthony of the Griffin family.
Are you the Anthony Griffin
of the
that is
estate
charged?
of
Stop a
Anthony.
second here.
You asked me a question, I'm answering it.
Okay, I don't want you to answer it anymore. I want a yes or no answer to a question, okay? And the question is, and I have to get the case back in front of me, I'm sorry, but bear with me. Lost my calendar. I have a simple question for you.
25 CF 939.
Are you Anthony Griffin with a date of birth of August 20th, 1985?
I am not the dead entity, Anthony Griffin. I am the executor of the estate. I do not agree to be.
All right, well, we'll have to set this over and hold you in custody then until we can have a later
I will check
hearing.
as I've been held for 72 hours without seeing a judge. That is unlawful.
But you're not Anthony
So
Griffin.
you are agreeing to violate my common law rights. Is that what you're saying?
I'm asking you to, let's do this, okay. I'm gonna find probable cause that this is Mr. Griffin, that is acting in an obstructing way, but we'll go ahead with it. Do you have a copy of the complaint there in front of
I
you?
object that you're obstructing my justice.
Your objection is noted.
I'm a more. You have.
If you keep talking over me, we're gonna cancel
You're
this.
talking over me. I just want to state the facts. Do you not want the facts to be stated on the case? Am I not allowed?
I mean, you're not allowed, no, you're not allowed to talk about it.
An attorney. I am not.
Okay, let's hold him in custody or canceling this hearing. You're gonna have to be
That's
held.
okay.
You're not willing to cooperate. Make a
Let the record show that you're violating my rights. Let the record.
Record will note that he refused to cooperate so that an initial hearing could be conducted. That's 25 CF 939 appearances.
ADA Assistant Region Marco for the state.
To understand where the Black Defender's Office refers to Mr. Griffin has indicated that he wants to take care of his own case. Right?
Is that right, Mr. Griffin?
I'm not Mr. Griffin, Anthony of the Griffin. I am the power of attorney for him. I do have a question for the court. Will I be allowed to speak freely or will my civil rights be again granted over?
Oh, you're gonna make a statement on bail, but we're gonna do this in an orderly fashion, but you're indicating that you're not Mr. Griffin, or that's just not how you identify yourself?
It's not about me identifying myself and the Griffin carries my all caps entity with the dead entity. I actually have an EIN for this created entity. This is not me. I also do not live this address. I'm also not a Black man. I am on board. So a lot of things on here are totally wrong, which not at all. My weight is not 240 pounds. All this information is false. But as for the record, all statements for the record comes now the living man and the other Griffin family. Sure, there is appropriate persona status appearing expressly to continue the record arrest accordingly. I'm not to be mistaken with the all caps estate, as I am the occupant of the executive office and also the sole beneficiary of the state. I filed my power of attorney with the court, and I'm ready to proceed. Let the record show that I do not agree to be a surety for the debt entity as it was created from the state and was given to me and is not a representation of me. I am not one who owes debt to the United States or to the state of Wisconsin. Further, I'm not a flight risk. The only reason I missed court was due to the failure of the court to notify me of said date. Furthermore, on being detained, I made it very clear to Officer Gilson that I wanted my rights read to me. Officer Gilson first refused after we asked him twice more than he read me my rights. After Officer Gilson read me my rights, I made it very clear to him that I wanted my attorney present with the sheriff. Officer Gilson then replied, "They won't come." I made it very clear to him that if he continued to talk to me without my attorney present and the sheriff present, it would be a violation of my civil rights and my constitutional rights. He ignored these facts and continued with the arrest in violation of my law and the rights and the protocol that he agreed to follow as an officer. I was pulled over while traveling in a private automobile. The plates read, DOT exempt, do not detain private traveler. I made it very clear to him that he does not have jurisdiction, but yet he forced it. I was never properly identified as a suspect. My fingerprints were taken under direct arrest of origin after I told them I did not want my fingerprints or picture taken until I have a court order from the judge. I do not argue with any of the facts in this charge against me. This is not me taking a plea. This is accepted for value and returned for value. All the charges contained in this case and use my exemption for discharge and set off the order to me immediately.
Okay. Well, I think there's at least a reasonable inference on the record that the person known as Anthony Griffin is the same individual in front of me. When they call Anthony Griffin's case, he came out of the holding cell. I don't know why he would do that if he's not. I gave you an opportunity to speak. I'm speaking now,
I
sir.
object.
You can object. There's no basis for it. I'm looking at the court records. Please don't interrupt. I'm looking at the jail records.
The Trust Act of 1666 says that when somebody claims their estate, you are to relinquish all of the things to them.
I don't know what you're talking about.
That's
I've never
okay.
heard that ever.
That also means that this
You
is not
can file your written motions,
not a
Mr. Griffin.
competent court with jurisdiction, and I challenge jurisdiction under Federal Rule of Procedure 5.1.
It's denied. The booking photo and the Spillman records match this particular individual.
Right to approve your
I'll
own
find
jurisdiction.
probable
A
cause.
man can be lord over his own case.
And where would you like us to send mail, sir?
You already have mail, I told you on file, it's P.O. Box, the Forest, Wisconsin,
Okay,
53532.
thank you.
And I have a right to be
What's-
on cognizance.
What's the state's position on bail?
Thank you, Your Honor. In this case, the state is asking the court to impose $1,000 cash bail with the condition that the defendant be prohibited from possessing any dangerous weapons as defined by the respective statutes. It's my understanding that the defendant posted $5,000 cash on his current pending felony case and then failed to appear in court. He is alleged to have refused to identify himself and has committed additional crimes while out on cash bail, which is, as we know, a general violation of bond conditions.
I object.
It's our position that
Wow.
cash bail is
Let her
necessary.
finish. We can't have this hearing. We are talking over people. We're trying to record it. What's the basis for the
The
objection?
basis for the objection is the fact that she has no basis of knowing who I am. I don't know who she is.
All right.
She's not even.
The objection's overruled.
Overruled an objection.
I ruled it, Mr. Griffin. Let her finish.
As far as that failure to appear, Your Honor, it looks like a bench warrant for a body only hold was issued on January 27th of this year in pending case 24 CF 907. That warrant was not served until almost 3 months later on the 17th of April this year.
So Your Honor, they're sure not that when somebody has a court date that they have to be served a court date so they know that it's there? Or is it okay to actually set a court date without notifying the defendant or the accused and then locking them up for one?
All right, and I gather you're alleging that Judge Highland did not send notice to you?
No, there's no certified anything there. There's no documented proof of service of anything of that date. I went to every previous court date and I don't skip court date. He didn't show up for the last 3 court dates prior to that, and I actually put in a motion for failure to prosecute, yet they still moved forward as if nothing was placed in and no one came to court except for me and the prosecutor, and the judge was, I don't know, hiding in the back or whatever the case may be. I filed an abatement, just to let them know I'm not the person who they're looking for, but yet I keep getting trampled over in court. My rights keep trampled over in court. You have this person standing to the left of me who knows me not at all, and yet I would like her to take the stand and talk about how she knows me personally, because you cannot be a beneficiary.
Well, we're not gonna be
She's
doing any of that,
as the
Mr.
state,
Griffin.
and she is not the state. I know her not. I don't understand what's going on.
All right, well, it looks like they mailed notice to the address that you had on file at the time.
So
But
clearly,
you're gonna have to take that up with Judge Highland. That case is not before me. Looks like he's issued a body only warrant. You can't get released on that until you have a hearing with Judge Highland in that case. I think given the history,
so it's clear that you
$1,000 cash bail is necessary. I will set that.
I object, and it's clear that
And that's
your
fine.
rights have been violated, and you're still moving forward. This is called an obstruction of justice.
Don't,
Let the
even if
record
your
show
rights have
that.
been violated.
Know everything that I've said.
It's all being recorded, Mr.
I'm
Griffin.
glad.
You would have the right to a preliminary hearing in 10 days. Do you want that scheduled?
But I don't want to sit in jail any longer.
Okay, well, you're gonna have to get a hearing in front of Judge Highland on the other case. Right now, you're not allowed to post any cash bail to get released in that particular case. I don't have any authority to do anything with that.
So if you don't have authority, then
You're gonna have to address
I object.
that
If you don't
case
have
with him.
authority to actually set me a bail, you do not have authority over me. Matter of fact, Your Honor, are you responsible for me if something happens to me?
All right, and I'll also order that you not use or possess dangerous weapons as it's defined by the state
Are you
statute.
responsible for that?
And because I haven't heard a response, I don't believe we have a waiver of time
I
limit
will
to
ask
set
you
a
again,
time
are you
preliminary
responsible
hearing.
for me if something happens?
And we are adjourned.
Okay,
Griffin.
since you're not responsible for me if something happens to me, let the record show that you are not. You got crazy. That's what bad for the city, never us.
Mr. Mattson, don't interrupt me, please.
Right,
Mr.
when I
Mattson,
talk
Mr.
to you.
Mattson, do not interrupt me, please.
I think your court's making a big mistake here.
Mr. Mattson?
I've never signed anything for
Mr.
the court.
Mattson, if you don't
in the
stop talking, I'm
contract.
going to your device.
Well, I didn't want
Mr.
Mr.
Mattson,
Daly
stop
as my
talking.
attorney. I'm a living flesh and blood man. They're trying to sentence an all caps name. And it's not me. I'm a living flesh and blood man. You're after a fictional person. The only one I've ever taken an oath to is God Almighty himself. There's only one lawgiver, one creator, one judge. That's God Almighty. That's who I recognize.
And sir, you are Robert Joseph Mattson, correct?
So I'm a living flesh and blood man, attorney for a public officer or statutory citizen judge. I'm a living flesh and blood man.
All right, you are the living flesh and blood man who's known as Robert Mattson, correct?
Attorney for Robert Joseph Mattson, which would be the all caps name. Judge, there was something that I was trying to talk to my attorney about. Before you let me out of the hospital, I was in the hospital or the jail. I was experiencing a lot of pain and trouble. The jail was not treating me properly. After I got out of the jail, I went to the hospital and they hurried and rushed me to Toledo Hospital where I almost died. Had I not been released from jail when I did, I would be dead in that county jail.
All right, Mr. Mattson, we're here
Yes,
for
sir.
your sentencing hearing today. I'm not really able to address issues of medical treatment while at the jail.
Well, I was just saying that there was
Mr.
something
Mattson,
I agreed
Mr.
to.
Mattson,
Yes.
Mr. Mattson, don't interrupt me, please. The medical treatment that people receive at the jail is not within my purview, and I'm not going to address that today. So,
Well, I was just saying I was going to correct my
Mr.
when I
Mattson,
talked
Mr.
to you.
Mattson, do not interrupt me, please. Have you had an opportunity to read and review your pre-sentence report?
I did with the secretary for Mr. Daly.
Have you had an opportunity to discuss your pre-sentence report with Mr. Daly?
I haven't had an opportunity to discuss it with him. I did with the secretary.
My secretary got a hold of
Mr.
him.
Daly, if you could just let me allow him to finish his answer. What were you saying, Mr. Matson?
I did with the secretary. I talked to her over the phone and told her everything looked good. And I believe Mr. Daly was supposed to get back a hold of me. I don't know if he got too busy or something else happened.
All right. Thank you, Mr. Matson. Mr. Daly, you wanted to say something on that issue.
Yes, my secretary contacted him in regards to the PSI. He said everything was right. He had no complaints about anything. I still tried to contact him back, didn't get an answer.
All right. So what we'll do is have, if Mr. Daly, if you'd be willing to step out into the hallway, we have an iPad out there that we can log into the Zoom session.
But
And
I don't think he needs that. He's ready to be sentenced, Your Honor. You have any other questions, Mr. Matson?
Yeah, Judge, I think your court is making a big mistake here. I've not.
I appreciate that, Mr. Matson. And we've
I'm not
discussed
doing
it.
any of my rights or immunities. I'm not a statutory citizen. I am sovereign. I'm not somebody who's under the
Mr. Matson,
jurisdiction. I've never signed anything for
Mr.
the court.
Matson, if you don't
in the
stop talking,
contract.
I'm going to your device. Okay? I've discussed all of these issues with you before.
Okay,
And
well, I object, but I mean,
Mr.
you're
Matson,
sentencing. That's what you're
All
doing.
right. I've muted Mr. Matson's device because he won't stop interrupting me. Mr. Matson, what I'm trying to tell you is that we have discussed these issues before. You've raised those issues. I've ruled against those issues. And ultimately, you pled guilty of your own choice to the controlled substance possession of narcotic less than 25 grams. And so I'm going to sentence you on that charge today. If you'd like, I will have Mr. Daly step into the hall and you can have a breakout session with him so you can speak with him about your pre-sentence investigation report. If you have questions or things that you want to talk with him about regarding that report. So I'm going to unmute your device now and I want you to tell me whether you want a breakout session with Mr. Daly or not.
Hello?
Yes, we can hear you now. You want a breakout session with Mr. Daly?
Well, I've tried to talk to Mr. Daly before, I mean,
Mr.
about this.
Matson,
And
answer my question. Do you
Yes,
want
sir.
a breakout session with Mr. Daly or not?
Your Honor, you're going to do what you're going to do. I mean, I've tried to talk to the courts and reason with the courts. I mean, if you're going to sentence me today, then I just file for an appeal. I'm an objection to anything that happens today. I was under duress when I took the plea due to my life was at stake.
Mr. Matson, please answer my question. Do you want a breakout session with Mr. Daly or not?
Mr. Daly hasn't been much of help for me, Your Honor. So I mean,
That is not an answer to my question, Mr. Matson. Please answer the question. Do you want a breakout session with him or not?
Sorry, Your Honor. It just ain't been doing me any help, no justice at all. I mean, I've already said what I had to say. If the courts is going to sentence me today, then that's what they're going to do. I don't agree with anything that's going on today. I'm sorry. It's just my life was at stake when I had talked to the courts.
All right, Mr. Matson, please stop
Yes, sir.
talking. So you refuse to answer my question about whether you want a breakout session with Mr. Daly or not. The law.
Well, I didn't want
Mr.
Mr.
Matson,
Daly
stop
as my
talking.
attorney. Yes, sir.
The record, I placed Mr. Matson on mute again because he's continually interrupting me. Mr. Matson, what I'm trying to explain to you is that you have the right to discuss your pre-sentence report with your attorney before the sentencing. I've asked you 4, 5, maybe 6 times now whether you want to have the opportunity for that breakout session, and you won't give me a simple yes or no answer. So what I'm going to do right now is ask Mr. Daly to step into the hallway. We'll set up that iPad. I'm going to put you in a breakout session with Mr. Daly in order to make sure that I comply with with your rights to have that breakout session. So at this point, I'm going to set that up, whether you want it or not, so that we have complied with that requirement.
Judge, I just had a repeated conversation earlier.
All right,
I mean,
Mr. Matson, you're arguing the basis of your conviction. Again, you pled guilty to this charge. What I'm asking you is, Mr. Matson, what I'm asking you is whether you'd wish to explain or challenge the accuracy or the relevancy of any of the information that is in your pre-sentence report. So is any of that information inaccurate?
Inaccurate as far as the person that reports they're trying to sentence in all caps names. It's not me. I'm a living flesh and blood man. You're after a fictional person.
All right. So with respect to that argument, what the court will say is that I will leave the information that is in the pre-sentence report in the pre-sentence report and deny what seems to be some kind of a request to modify the pre-sentence report based on an argument that doesn't state any cognizable legal theory about a difference between Mr. Mattson as a human being and Mr. Mattson as something else. So the pre-sentence report will stand.
Well, Your Honor, you never even explained to me what the jurisdiction was. I tried from the beginning to
Mr.
see what the
Mattson,
jurisdiction
all
of
right.
the court is.
I'm going to mute Mr. Mattson again because he continues to interrupt me with a line of argument that I don't even know what to say about it. It just is, it's not a legal argument at all. It is some kind of fanciful belief that there's a difference between Mr. Mattson, the human being, and Mr. Mattson as some other entity, which is not recognized by the law, and I'm not going to entertain it any further. The probation officers calculated the minimum sentencing guidelines in this case to be from 0 to 9 months. Do you agree with that computation of guidelines?
I do, Your Honor. I do.
Thank you. Before the court passes sentence, Mr. Daly, is there anything you'd like to say on behalf of Mr. Mattson?
I've had the same conversations with Mr. Mattson the courts have. He's never wanted to talk about this case. He's always wanted to talk about what he perceived are constitutional issues. He pled guilty. He knew what he was doing. I do know that. I'm prepared to complete the sentencing now.
All right, Mr. Mattson, in a moment, I'm going to unmute your microphone and I'm going to give you an opportunity for allocution. That's an opportunity to say anything that you'd like to say on your own behalf before the court passes sentence.
Yes, sir. Can you hear me?
Is there anything you'd like to say on your own behalf?
You said that. I can say anything that I wish before sentencing.
You can.
I'm sorry, sir.
You can.
Okay. Yes, sir. Your Honor. I mean, before I took that plea, I told Mr. Daly that I wanted to sit there. I wanted him to sit there, get the cameras for the courts to prove that I was at the court date the day that I was put in jail, and said that that I wasn't in the court for a contempt of court. He said, and I told him I wanted to fight my case, but I had to be out because I had medical issues. Mr. Daly said that's fine and all, but if you stay here and you fight this case, they'll keep you in here for a year fighting your case. You will not be let out of jail. Your Honor, I couldn't do that. I was in major pain. I would have died in that jail. My proof is within the doctor's records in the hospital. I had a serious condition which would have left me dead within a week from the time that I took the plea. The following day after I got up, my wife was killed in a car accident. Just everything's been going downhill for me ever since. And now this with the courts. I don't feel that I've had a fair chance with the courts ever since I even started with the court, because the courts has not proven jurisdiction to me. I've not written any papers out agreeing in the contract saying that the courts can have any kind of jurisdiction over me. I have not relinquished any sovereign immunities that I have. I just don't feel like there's been anything fair, which is not going to be with the court system. I mean, I've tried to say I'm not a statutory person who is within your jurisdiction. If anything, I'd be considered constitutional, but I'm not even under the constitutional laws, but I will use them if I feel necessary as a constitutional living flesh and blood man. There is no injured party. The only injured party would be the state's laws, which the state cannot be the prosecutor, the injured party, and the judge. There's nothing's right. The court case either had been dismissed or moved to a higher court. And I wasn't going to sit there and be left in jail to fight my case for a year. I would have been dead. I've been stupid not to sit there and just agree with a plea that I didn't even agree with in the first place, just to save my life. I don't think that's fair at all. It's not right. There's nothing but wrong here. It's injustice, not justice. You can't be a constitutional person and a statutory person at the same time. Either you're one or the other. And Wi-Fi wasn't working properly on my computer. I couldn't draw up my own paperwork. I've been in nothing but severe pain. I've been able to move around and do much of anything for myself. The only one I've ever taken an oath to is God Almighty Himself. There's only one lawgiver, one creator, one judge. That's God Almighty. That's who I recognize. For me to sit there and agree to anything more than that would be me sitting there violating the laws of my God.
All right. In determining the appropriate sentence in this case, the court has considered the seriousness of your offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the report and recommendation of the probation department, as well as what's been said on the record here this morning. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, vindication for the law, and the protection of society. As indicated, with respect to these sovereign citizen or whatever the other arguments you're making are, we've dealt with the jurisdiction issue in the past. I've ruled on that on at least one occasion, probably multiple occasions, and that ruling is not going to change. You will have appellate rights if you want to pursue those. You're welcome to do that, but you have pled guilty in this case. I think under normal circumstances that would be an adequate recommendation. With he's gone.
Oh, is Robert Matson there, please? Okay, who am I speaking with? Okay. All right, thank you. This is Mike Stevenson, probation. Okay, he had sentencing this morning. He just left the Judge, I just spoke with a female at the number that he gave me, and she claims that he is at a heart doctor appointment at this time. That's what she claims.
Everyone back with us now. Mr. Matson, we are in a court proceeding right now, and so I'm going to ask you not to eat anything and to remove your hood. All right, I'm going to ask you to remove your hood also, Mr. Matson. Thank you. Mr. Matson pled guilty to one count of controlled substance, attempted possession of cocaine, heroin, or another narcotic of less than 25 grams, pursuant to a plea agreement which dismissed one count of possession of cocaine, heroin, or another narcotic, dismissed one count of driving the license suspended, and one count of alcohol open container. So the agreement was to one count of attempted possession of a controlled substance, dismissal of the remaining charges, and that was apparently incorrect. There was no sentencing agreement in this case. This is Mr. Matson's first felony conviction. He does have 4 prior misdemeanors. Those are all from 2015 or earlier. He has 2 2015 cases and a 2002 and a 2001. And so the recommendation in this case from the probation officer is for a period of 1 year of probation. And I think that, well, it also, I should say, includes restrictions on alcoholic beverages and substance use. And I think that those provisions of terms of probation are appropriate given Mr. Matson's Compass Needs Assessment scores. He did rate as highly probable in the categories of substance abuse, family criminality, residential instability, and social environment. He does have a substance abuse history of cocaine, fentanyl, painkillers since 2005. I think that it is appropriate to try to get Mr. Mattson some help for his substance abuse problems. The concern I have in this case is that is whether or not Mr. Mattson is going to be willing to comply with the terms of his probation. He has, in numerous court hearings in this case, made a number of what he believes are constitutional and jurisdictional arguments that have absolutely no legal merit whatsoever. And he continued to challenge the court's jurisdiction here this morning. I understand that that may be an honest belief that Mr. Mattson has, and I don't know where it comes from, but I will say Mr. Mattson would be far better off taking legal advice from Mr. Daly than from wherever it is that you're getting it to make you believe these arguments, because as I've ruled repeatedly, there's just no merit to them. They're not rational or coherent arguments under the law. And the concern that that raises with me is that Mr. Mattson, if he does not believe this court has jurisdiction, why then would he follow the terms of his probation? And so if that's the question, then the question I have to ask myself is why would I put him on probation if there doesn't seem to be any indication that he would follow the terms of the probation? The other side of that coin is that I think a lot of this stems from Mr. Mattson's substance abuse issues, and the better way to get him help for his substance abuse issues is to put him on probation and get him into some kind of services to help him.
When a person's beliefs conflict with the system around them, they may protect the belief instead of changing their strategy. What that means here, the jurisdiction argument may feel personally consistent, but rejecting the court's authority while accepting probation creates a direct strategic conflict. The judge now has to weigh rehabilitation against the risk of non-compliance.
So ultimately, Mr. Mattson, I'm going to give you a chance at probation. I hope that you are willing to comply with the requirements that are outlined in terms of your probation, which I'll read to you word for word in a moment so that you're aware of them. If you choose not to comply for the reasons you've stated or any other reasons, you can rest assured you're going to find yourself in violation of the terms of your probation. And then I am going to be imposing other penalties, meaning for you jail time. And I'll just tell you now, it'll be a short leash, because if we continue down this road, I'm already suspect of your ability to comply. So any violations are just going to confirm that for me, and you're going to find that I'm going to lose my willingness to give you a chance. So it will be the sentence of the court that you serve a period of probation for 1 year, that you serve 29 days in the Lenawee County Jail with credit for 29 days served. You must not use or possess alcoholic beverages or other intoxicants. You must not enter bars or other places where the primary purpose is to serve alcoholic beverages for drinking on site, unless the field agent has first given you written permission for your employment at a specific location. You must comply with the requirements of drug and alcohol testing as directed by the field agent. You must not attempt to submit any fraudulent or adulterated samples for testing. You must not hinder, obstruct, tamper, or otherwise interfere with the testing procedures. And you must present proper identification at the time of testing. You must pay the cost of your substance abuse testing You must not be in possession, you must not use or possess any controlled substances or drug paraphernalia unless prescribed to you by a licensed physician. You must not be with anyone that you know to possess those items. You must complete an outpatient or residential substance abuse treatment when you are referred by the field agent. You must complete a substance abuse assessment when you are referred by the field agent. You must pay a $30 per month supervision fee, so long as there's no electronic monitoring. If electronic monitoring becomes necessary, that fee increases to $60 per month. You must also pay court costs of $750, an attorney fee of $450, a crime victims' rights fee of $130, and $68 state costs. And that, Mr. Mattson?
Yes, I do. Hey, Judge, I just had a couple questions, if I may, from you. Concerning what you just said.
All right, what's your question?
Well, if there's a crime victims fee, I'd like to know where the victim is, and also, Your Honor, you said something about the jurisdiction. If there's no problem with the jurisdiction, I mean, how come you couldn't tell me exactly which jurisdiction you're operating under? Because I would have to object to what you said. I mean, it don't make no sense to me, Your Honor.
I told you that before, Mr. Mattson. I'll tell you again. I'm operating under the jurisdiction of the Michigan Constitution that sets forth the fact that the state has various circuit courts. I'm the judge of one of those circuit courts. That one be where you are alleged to have committed this crime and where you pled guilty to this crime. As far as the crime victims' rights fee, that is assessed in every case where there is a guilty plea or verdict. That is done pursuant to statute that was enacted by the Michigan legislature, and it is required to be imposed here. So that is why I did it.
The two proceedings show the same basic problem from different angles. Once a person turns a courtroom dispute into a fight over whether the court has authority at all, ordinary legal decisions become much harder to resolve. In the first case, the defendant repeatedly challenged his identity and the court's jurisdiction instead of giving the court a straightforward answer. The judge ultimately relied on the records in front of the court and continued with the probable cause and bail process. The important point is that a jurisdiction objection is not automatically powerful simply because it is stated with legal-sounding language. The court has to recognize a legally valid basis for the challenge. In the second case, that issue became even clearer. The judge explained that the court had already rejected the distinction between the defendant as a human being and the legal name appearing in the case. The court treated that theory as having no recognized legal basis, while still allowing the defendant to preserve appellate rights. There is also a major difference between challenging a ruling and refusing to work within the consequences of that ruling. The second defendant had already pleaded guilty. At sentencing, the court therefore moved toward the practical question: what sentence and conditions were appropriate? The judge ultimately gave him probation, but specifically connected that opportunity to his willingness to comply. The warning was straightforward. Continued violations could lead to additional penalties, including jail. That is where courtroom strategy matters. A person can preserve an objection, pursue an appeal, and still comply with the current order. Those are not mutually exclusive choices. Once the legal system has rejected an argument, continuing to repeat it does not necessarily strengthen the position. It can instead shift attention toward compliance and credibility. Across both cases, the central lesson is simple. A legal strategy has consequences not only because of what a person believes, but because of what that strategy causes them to do next.